Hi, Robert Gruler here. Today we're talking about criminal damage in Arizona. This is an Arizona revised statute violation, not a city code violation. And it's something that can be quite serious or it can be quite minor. And a lot of that depends on the value of the damage to the property. So if you look at the statute, it says that in order to be convicted or guilty of a criminal damage offense, you have to recklessly do something to somebody else's property. That can be another person's property, it can be another utility company property like a light pole or a transformer box. Some damage needs to occur to property. So it's a crime against property and not a crime against a person. And the severity of the crime, whether it's a minor misdemeanor or whether it's a very serious felony, will depend upon the value of the property that was damaged. So let's dive into that and let's take a little bit closer look. Of course, we will go to the whiteboard. So here we have a breakdown, and I've written it out prior to hopping on the camera here, a breakdown of how the statute works. Now there's several different subsections of this statute, but what we're really going to be looking at, because these are the two most common types of criminal damage, are these two subsections here. So if you look at the Criminal Code 13602, what you're going to see is you've got two different subsections. So the first one is saying that you can be guilty of criminal damage if you damage or deface the property of another person. Okay, and that's the first one. Now it can be utility companies as well, as I mentioned earlier, or the other way that you can get it often is when you substantially impair the value of that property, or you impair the person's ability to use that in a way that's substantial. So say, for example, if you're talking about a cell phone, you may not totally destroy that property. It may not be damaged to the point where it's not functional. It may still function, but the screen may be broken. A person may not be able to use it as he or she would normally do so. And so that might be charged under that particular subsection, so it's substantially impair. There's other ways that you can do criminal damage. Some of them are a lot less common, things like interfering with livestock and those types of things, but we don't see that often, if at all. These are really where we see it most commonly, so we're going to focus on these things. So again, you have to do something recklessly, and we're going to dive into that a little bit because some of that can be difficult to interpret given the facts of your specific case, and so we'll talk about that shortly. But before we get there, let's talk about how this law applies in terms of what the penalties are to you if you're being charged with this, how it will apply to you, and as I said earlier, it's going to be based upon the actual amount of value, the damage that was caused. So I have written out here how this is broken down in terms of different classifications of crimes. So we'll start at the top. So if there's criminal damage, if there's impairment of value to property, or if there's a destruction of property, and this is to a person, we're not talking about utility companies. The values for a utility company are lower, but if we're talking about damage to a person, it needs to be over $10,000, and if it is, it's going to be a Class 4 felony. So if it's a major damage, something that significantly damages like a home or a vehicle, if there's something that has a lot of value to it and it's damaged, and the cost or the cost to replace that value of that property is over $10,000, they can charge that as a felony. It'll be a Class 4. If it's over $2,000 but under $10,000, that'll be a Class 5. If it's over $1,000 but less than $2,000, it'll be a Class 6. So these are all felonies. Those will be handled out of a Superior Court of Arizona. Obviously, felonies are significantly more serious than a misdemeanor or a lower level offense because that can really impair. It can actually carry prison time depending upon what your history looks like. But it can also, impair your or preclude you from voting. You can not be allowed to carry a firearm anymore. It can very, be significant in terms of applying for jobs and those types of things. So you want to make sure that you understand that if you're being charged with a felony, the consequences are drastically more severe than if you're charged with a misdemeanor. But if the value is lower, so if it is under $1,000 but over $250, it's a Class 1 misdemeanor. So this could be heard in a separate court, generally a city court. Or if it's any amount that's under $250, this is a Class 2 misdemeanor. So this is the middle of the road misdemeanor. There's a Class 3, which is the lowest, and so you're talking about the highest misdemeanor and the middle misdemeanor, or you're talking about felonies. Now, the most common criminal damage charges that we see are these. Okay, they are the misdemeanors. They just tend to be the most common. What will generally happen is a couple or a group of friends or somebody will get in a fight. Some property is damaged. It's usually not property that has a tremendous amount of value. Like I said, it's usually a cell phone, or there's a fight and it's a lamp, or somebody breaks a dish, or it's something like that. That typically is not in the amount of the value of that property is not over $1,000, which means it's going to be a misdemeanor. Now, if there's some dispute about what the cost or what the value of that property is, it's up to the prosecutor to make that determination. So they can say, well, in our interpretation of the value of that property, we're going to say it's very high, and so we're going to rise it, or we're going to escalate it. We're going to consider this to be a felony, whereas some other prosecutors may look at that and say, this doesn't rise to that level, therefore we'll charge it as a misdemeanor. And so that's where you fall into this, to kind of the scheme of things here. Depending on what actually happened, what was damaged, the amount of that value, that's going to determine where your case is going to be filed and at what level. All right, so if that is the case and you have been charged, now what? Now you certainly have to defend against that, and it's very feasible to do that. There's a couple key points that we want to talk about here, and I have them listed out. So first and foremost, we want to talk about what is reckless behavior. Okay, this is defined in the Arizona Revised Statutes, but the kind of the brief explanation of it, the quick and dirty of it, is when you're acting in a way that deviates from the standard norms grossly. Meaning there's a big deviation from the standard kind of operating procedures of everyday life. If you're doing something that is a gross deviation from that, that is very likely going to meet that element of reckless, okay? And that is in the statute. That's in the statute if you look it up. So the question then becomes, okay, if there was damage, and if you are the person who caused that damage, what was your activity reckless? Did you trip and slip and fall and break a lamp, and that was an accident? Or were you headbanging, drinking too much, getting in a fight, and that caused the damage? So there's going to be a lot of ambiguity over that term of art there. What is reckless? And did the activity or did the actions in your particular case meet that level? Okay, this is an element of the statute that needs to be met. And so there can be argument about that, whether or not your activity or the actions that occurred in your case actually rise to that level is open to interpretation, and a lot of that is going to be very fact-based. Okay, the other way that we want to defend against criminal damage charges, and we see this a lot surprisingly, is when we're determining whether or not that property actually belonged to another. We see this most often in sort of domestic cases where a couple will be getting into a fight, somebody will slam a drawer, or they'll slam a dish, or something will break that's pretty low in value. A neighbor may hear that, they may call the police. The police appear. It's pretty clear that somebody broke the plate, but whose plate was that? Okay, was that somebody else's plate? Was that person A's plate who's being charged with the crime, or was that person B's plate? In other words, did they break somebody else's property? Is really what it comes down to. Can you be charged with criminal damage for breaking your own plate? If I took my marker here and snapped it in half, could somebody charge me with criminal damage? Well, maybe, because this is my legal assistance marker, but the point is, if it was mine and I broke it, I'd be okay breaking it. It's my property. It doesn't meet the statutory element of being another person's property. And so sometimes there's a dispute over that. What is somebody else's property? What is mine? What is theirs? If you break your own thing, can you be charged with criminal damage? And the answer really is no. So sometimes there's a dispute over that, and remember, if you're being charged with criminal damage, they've got to prove that element. Okay, they've got to prove, they need to have some sort of testimony or some sort of admission, or there needs to be something that is proving that this element is in effect true, that this property in question in this whole case was somebody else's. All right, the other way that we get into a strong defense for criminal damage is when we talk about causation. Okay, so causation comes into play where we're saying there was a person A who was there, we have a piece of property that was broken, but they can't link the two. They can't link that person A actually was the cause of the broken property. This happens a lot also in domestic situations where somebody else will call the police will appear, there will be very clearly damage to the property, somebody will say somebody else did it, somebody else will say somebody else did it, There's conflicting stories, so there's no real way to tie one person to the actual damage. That's called causation. The cause of the damage is difficult to ascertain. It can be difficult, especially in misdemeanor cases when we're talking about this circle in red here, to bring people into court, to actually have witnesses come in and tie those two elements together. So you've got an individual, you've got damaged property, but you need somebody to tie them together. You need somebody to testify that this person actually was the cause of that. So if you can break that up, and if you can show that they don't have a clear connection between the two, you might win on causation alone. And if all of these things fail, and they prove all of these things very clearly, one kind of last defense, and this is more of a last resort type of thing, this is presuming that all of these other elements are okay, but you can't argue damages. You can say, all right, I acknowledge I did break that. I was the cause of it. I was acting recklessly. It was somebody else's property. In other words, I meet all of these elements, but the amount of damage was not as severe as you say it was. So for example, if somebody says that, I broke something that was valued at $2,500, that's going to put me at a class 5 felony. Well, if I dispute that and I say, no, I disagree, it was actually $100 because of all of your inflated measurements, all of your analysis on coming up with that $2,500 figure are totally inaccurate. It's actually a $100 piece of whatever. That would put us down in this category. And so that would take us from a class 5 to a class 2. And very obviously the consequences for a class 2 are considerably less severe than a class 5. So if all of these other elements do kind of meet the statutory requirements, you can always argue about damages, and that may save you a tremendous amount of penalties and sort of potential liability in terms of being convicted of a felony. So those are the main ways that we generally defend against criminal damage charges. Of course, there are many, 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 many more different avenues and different kind of techniques and angles that we take. But if you've been charged with criminal damage, it is a very fact-specific, fact-intensive analysis that we have to go through. So if you'd like to, you can come into our office, sit down with me or a member of my team. We'll lay out the facts. We'll put together a plan for you to make sure that you can be as successful as possible in your case. Thanks for watching.